Good evening. I'd like to welcome you all to this evening's licensing subcommittee. Before I hand over to members, I would like to advise you of the protocols for this evening's hearing. Can I request that you only speak when invited to do so by the chair? If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you are not speaking, apart from the chair, who does not need to mute their mic at any stage of the proceedings. When speaking, please be succinct and do not exceed the allocated timeframes. If you're referring to something within the agenda pack, please be specific, referring to the specific page. If you are having any technical difficulties, please use the chat function to alert the meeting, and we will try our best to assist you. Please do not use the chat function for putting formal questions to the subcommittee. Any disruptive behaviour will result in removal from the meeting. Once all applications have been considered, any remaining parties will be asked to log out of the hearing. Please do so promptly so that councillors will have the opportunity to deliberate and make a decision on each application they have heard. Each party will be notified of the decision within 5 working days. However, if you do contact the licensing service tomorrow, you will be given a skeleton decision. At this stage, I would like to hand over to members and invite them to elect a chair. Thank you very much.
Sorry, I nominate Councillor Smith.
Seconded.
Oh, great. Thank you very much, everyone. And welcome to this licensing subcommittee C, Thursday, the 16th of June at 7 o'clock. I think what I'd like to do to start with is just to go through and just introduce ourselves very briefly. So I'm Councillor Smith, Stoke Newington Ward, and I'm currently the chair of licensing. Jan?
Councillor Ossan for London Fields.
And Sophie?
Hi, I'm Councillor Conway. I'm Councillor for Hackney Central.
Suba?
Subhashri Ramana, the Principal Licensing Officer, will be presenting the report.
Thank you. Amanda?
Good evening. I'm Amanda North from Legal Services, and I'm assisting members this evening. Thank you.
Okay, and you've heard from Natalie. So thank you, Natalie. And Kerry, PC Ryan.
Good evening, Kerry Ryan, Hackney Licensing, the police.
Okay, and the chap there from OKKO.
Yeah, it's Craig McIntyre from Oko Restaurant, 49 Broadway Market and 47 Broadway Market.
Okay, brilliant. Thank you, Craig. And then I've got, I believe it's the lawyer at the top there, but there's no name for you. So I'd like you just to tell me who your name is.
Me, sir, yes?
Yes.
Yes, thank you. So apologies, I couldn't enter my name. My name is David Dadds, D-A-W-D-S. I'm counsel on behalf of the applicant. I represent By the Bridge. I understand that we're possibly going first, but I'll be directed by you.
Okay, brilliant. That's great. And then Mario is our sort of technical IT whiz kid. So thank you, Mario, for all you do for us. So yeah, you've got the agenda in front of you, hopefully. So what we plan to do this evening is to basically swap item 6 for item 7, if that's okay with everyone. So yes, By the Bridge would be taken first, David, if that's okay. If you're happy about that.
Yes,
so we've had the election of chair. So item 2 on the agenda is apologies for absence. I don't think we have any today. Item 3 is are there any declarations of interest? Do members have any declarations of interest? Jan, I can't hear you.
No.
Good, thank you very much. Item 4, minutes of previous meeting. There are no minutes for consideration. And then item 5 is the hearing procedure. So we just go through kind of what we do. So ultimately, there are various steps to this, steps 1 to 10. So step 1 is the appointment of the chair, an introduction, which we've kind of done. Step 2 is where the licensing officer will outline the report. Step 3, the applicant will present their case in support of their application. Step 4, we have responsible authorities speaking if relevant. Step 5, other persons. The other person for item The first item, which we swapped, is not here, and that's why we swapped it. Step 6 is a discussion. Step 7, closing remarks. Step 8, final clarification. And then step 9, basically, you all leave and we kind of consider our verdict. So in terms of the licensing officer's report, that's 5 minutes. Everything's 5 minutes, by the way, apart from the discussion, which we get 15 minutes for. So if we could try and stick to the time frame, that would be great. But obviously, we can be flexible there. Amanda, can't hear you. You're on mute.
Sorry, apologies. As the first item has to go first and Councillor Ozen will be leaving us at that point, I think we may need to have a 5-minute break with him in the out of this meeting, if that would be okay, because I don't know whether or not he'll return at the end of the meeting for consideration.
Oh, I see what you mean. Yes.
Yeah. So do you want us to have a 5-minute break at that point, only because we might need to, otherwise we have to keep him waiting.
Yeah,
or
good
he'll
point,
have to come
Amanda.
back.
If everyone's happy with that in the meeting, that would be preferable, I think.
Yes.
Is that okay for you, Jan? Does that work for you?
Yeah.
And everyone else? Councillor Conway?
Yeah.
Does it work for you? Yeah?
Yeah.
Okay, great. Okay then, so we'll just move straight on then to step 2, which is, could we ask the licensing officer please to outline the report? Thank you.
Thank you, Chair. Licensing service are received of an application for a premises license under Section 17 of the Licensing Act 2003 for By the Bridge, 283A, Kingsland Road, for late night refreshment and to authorize the supply of alcohol for the consumption on the premises as stated within the report. Environmental enforcement will do the representation based on agreed conditions from 27 to 32 as set out within the para 8.1 of the report. Representations remains from the police and the licensing. I have nothing else to add. Thank you, Chair.
Thank you very much. Okay, so step 3 now is we invite the applicant, I presume it's Mr. Dadds, to present your case in support of this application. Thank you very much.
Thank you,
5 minutes.
Thank you, Councillor Smith. Relatively straightforward application. The issue that is not sort of set out here, some of the issues, is that we've had the premises in our care for about 8 years and it's been licensed for over 6. There are no matters of crime disorder, antisocial behaviour, no complaints from environmental health, and we've been promoting the licensing objectives. You'll hear from the police that they've never been called to our premises or any matters arising. No material matters from environmental health, no material matters from licensing in the way we operate historically, until we made an application down the road for another premises. My client does feel somewhat harassed by the licensing and police service, but that will be a separate matter for a separate day. I ask you, Chair and members, to look at this application on its own merits. It's had a substantial long trading history without any matters arising at the premises promoting the licensing objectives. As I say, no objections from any local councillors, no objections from any local residents, no objections from environmental health, no objections from planning authority. The objections that we do have are scant and vague, and I ask if you will exercise your powers to make sure through the discussion you draw out any actual crime disorder matters or any matters formally made by a licensing authority or the police service. And I will touch briefly on the other matters of alleged breach of condition lately after. But remember, this is a new application on its own merits. You'll see that conditions 8 through to 26 are substantial. 27 to 32 are from the Environmental Health Service, which have been agreed. The premises is small. The hours are, we believe, within framework. And as I say, no council or residents have objected. The local police service raised a number of points in their representation at page 81. Premises regarding or comments regarding a premises around the corner are not relevant. Matters around the corner are not relevant. This premises was subject to a number of visits where it's alleged that the alcohol was provided in breach of a condition. We say no, that's not the case. I've spoken to the police service saying we're happy to have a meeting with them if they so wish, but they will need to deal with it formally. We don't accept there's a breach. And it's not right, Chair, that we should be dealing with those matters today. We are innocent until proven guilty. We are a common and golden thread through any process is that we should have the opportunity to defend ourselves if we don't agree with the police service, and we don't, and that we have not received any summons or any disclosure, no interview, no informal interview. So is that not even started down the process of any formal enforcement action other than informal with a warning letter, which we reject is not valid or baseless. There's been over 3 months, I think, since the last visit. We have secured all our CCTV. We are satisfied that we are in compliance with our licence. But in any event, this licence, if granted, will deal with that concern raised by the police that alcohol was provided not in accordance with the licence, i.e. not ancillary. We're a small business. We do provide food. That is our main primary business. But we want to allow customers to come in if they want to buy a drink or have a drink or have tapas or some small snacks. We are a tiny, small premises, normally about 10 downstairs and no more than 30 upstairs. The issues are around health and safety. We have health and safety, no objections from health and safety. The premises structurally sound. The stairs are sound. No issues arising at all from the fire service. We say that the matter, this application should be granted because the trading history, we won't undermine the licensing objectives going forward. And lastly, there's no primary evidence here at all. No witness statements, no evidence of crime and disorder, public nuisance, any complaints from residents. We are good and well-managed premises, and we ask that this application on its own merits be granted as applied for or in accordance with the conditions that we have agreed to. I believe that's almost 5 minutes, and I'm happy to answer any questions you have at that time.
Thank you very much, David. That was 5 minutes and 20 seconds. So that's superb timing. Just very quickly, do we want Councillor Conway, Councillor Ozen, would you like any points of clarification you'd like to raise at this point, very briefly?
Not at this point, no.
No, Councillor Ozen.
No, but I like to know. I mean, I like just the entries of the premises. So just is it from the side road or main road, as I asked before?
Yeah, the entrance, I think, Mr. Dads, is it from the front or the side?
It's the front on the main major road on the arterial.
Brilliant.
Thank you.
There is one point of clarification I'd like to make before we get into other representations, and that is that the Environmental Health Authority did put forward an objection based on litter. Did you see that one, Mr. Dads?
Yes. So what it is that I apologise if I misspoke, but there's the pollution. They didn't raise any issue, and then I think there's environmental for waste. The Environmental Health Department break down into certain sections.
Yeah.
So from noise pollution, I don't believe there were any objections. From waste, there were some which we've agreed those conditions which are set out in
Okay,
the
great.
agenda.
Brilliant. Thank you for that.
Thank you, sir.
Okay, so if we could move to responsible authorities, please. So I think we've got PC Ryan from the police. You've got 5 minutes, PC Ryan. Thank you.
Thank you, Chair. Police have submitted representations in relation to this application and did so in early to mid-April. And since those submissions, we have not had any contact whatsoever from the applicant or agent, except when police have conducted a proactive visit. Unfortunately, during that last visit, which was on the 25th of March, as Mr. Dadd stated, it was at approximately 10 p.m. The manager, who refused to give his name, was extremely unhelpful and difficult, and the owner, Mr. Tesgall, who arrived a short while later, became argumentative and confrontational. Breaches of the excuse me, of the license, in particular the alcohol being sold ancillary to food condition, was identified, but police left when discussions were no longer able to continue in a calm manner. Mr. Tesgall accused police of harassment, as we have visited him on more than one occasion. What kind of police officers would we be if we did not investigate suspected breaches of the premises licence and knowingly allowed them to continue operating in this manner? It's my job to ensure that the licensing objectives are being upheld at all times, in particular the prevention of crime and disorder objective. Consistent breaches of conditions on a premises licence, in turn, means that any sale of alcohol under that licence is then unlawful. This is an offence which can incur a hefty fine and/or imprisonment when enforced. This application has been made in the name of HS Hackney Limited. Company's House shows that there is one person linked to this company, and that's Ms. Hande Sezgin. I hope I pronounced that right. Ms. Sezgin is a partner of Mr. Tesgall, and between them they have interest in at least 2 other venues within a 50-metre radius of this one by the bridge, which is the relevance to the other premises that Mr. Dadd's touched on. Those premises over the past year or so have been subject to committee hearings similar to this one. One premises was refused premises licence, and another was reviewed by Hackney Council officers, whereby conditions were imposed to prevent Ms. Hande Sezgin entering the premises when it was open to the public. It's interesting to note that one of the main contributing factors to the review of that licence was the consistent breach of the conditions, one of them being the sale of alcohol ancillary to food. I'm aware that planning issues will not have a bearing on this decision that the committee made today, but it should be noted that it's a concern that the roof terrace is being used by customers, despite A, not being currently on the plan for the current licence, and it not having planning permission. I did request a health and safety assessment and or a fire risk assessment from the applicant in my representations back in March, but haven't received anything. And on my last visit there, I climbed the stairs, and they're very steep, very narrow, very awkward to navigate. And I imagine that if it rained, it would become very dangerous and slippery for people that are trying to come down the stairs. It's also noted that this application is almost a mirror image of the licence that currently exists at the premises, the exceptions being the absence of an ancillary to food condition and allowing drinks outside the front of the premises, despite them describing themselves in their own application as a licensed restaurant. This application only seeks to confirm police suspicions that this premises wishes to operate a bar, and the reason that the premises was granted a licence in the first place years ago was because they describe themselves as a restaurant. Police have very little confidence in the operator, Ms. Sezgin, as she has a proven track record for consistently breaching conditions, not only at this premises, but her other venues. And it's a shame that relationships between police, Mr. Tesgall and Ms. Sezgin are not as they should be, but a refusal to work with police and discuss their operation in a calm manner has meant that we've been left with very few options. The introduction of a new DPS doesn't allay our concerns at present, as we know nothing about them or how they manage and run licensed premises. So please respectfully request that this application be refused in its entirety. Thank you.
Okay, great. Thank you. That was 4 minutes and 30 seconds. Lovely. Thank you for keeping to time, everybody. Now, the licensing authority can't make it this evening. There was an emergency issue there, but they have made a representation in the documentation, which is here. So I suggest we kind of move on to the discussion phase. And I'm just going to open up the floor to the 2 members, Councillor Conway and Councillor Ozen, just for initial questions. I know, Mr. Dadd, you want to come back on a few things there. just to start the discussion off, should we start with Councillor Conway, please? Thank you.
Hi, thank you. I just wondered if there was any sort of specific response in relation to what the police have said about the use of the roof terrace.
That's to Mr. Dadds, yeah?
Mr. Dad, sorry, yes.
Yes, we can use and do use the roof terrace for non-licensed way activities. The roof terrace is structurally sound. The stairs are correct. We've got health and safety. We've got our documents. There's no issue. And if there were, I think we would have representation from the Health and Safety Authority. That there is no issue with the roof terrace or the stairs. And remember, pollution team know that we're applying. We already have an existing license. So there's criticism of Mrs. Seskin, but Mrs. Seskin is already the premise license holder, operated the premises for 6 years. The question I had asked, I hope one of the members will ask the police about, has there been any prosecutions, any found guilty of any breach of condition, any prosecutions, any cautions, any arrests? There's none of that. It's all about muddying the water. This premises, there's been never any crime or disorder. Been operating 6 years with a premises license.
Any further questions there?
No, not from me, although it would be, I would like to actually know from the police, if there were any further actions that have been, why further actions hadn't been taken, I suppose, in relation to, I think the last visit that you mentioned, where I think, correct me if I'm wrong, you said that you'd seen, is it sales of alcohol that weren't ancillary to?
It's all alleged as well.
So I just wonder what came of that, and what steps you took beyond that.
That was the warning letter that Mr. Dad spoke about that they dispute. I mean, we prefer to work with the licensees. It's a last resort that we bring them to review or to prosecute. We like to work with the licensees to build up a relationship with them so that we can work together. Unfortunately, that hasn't been the case at the moment, and because there's been another license application pending, we wanted to go through this process first before sitting down and trying to have further discussions.
Mr. Daz, do you want to come in? And can I just, well, I know you want to answer that to the police, but just to sort of reiterate the point about the kind of, quality and track record of the management, if you could just speak to that a little bit, because obviously that seems to be concerning the police.
Yes.
And if there's anything you can say about, the kind of good character of the applicant.
Yes, thank you.
Or otherwise.
Yes, thank you, Chair. I'm a bit sort of, I'm a bit stuck because the premises itself has had no cautions, warnings, prosecution. Mrs. Seskin is a person of good character, so she has no conviction. She's a licensee. She's held a license. She's there. If the police have primary evidence of a breach, sale of alcohol without food, where's the witness statement, section 9, signed? Where's the CCTV? We have been getting visit after visit after Concordat, or the graduated approach to enforcement from the police, says that you will ask the licensee in for a interview, set down the causes of concern, tell them what steps that they are required to take, i.e. action plan, and that if they don't do that, they will seek a review. And there's a graduated approach to that, or prosecute. None of that has happened, and we don't accept it. But more importantly, Councillor Smith and Councillor Conway, that there's been no crime disorders, no suggestion of drunkenness, underage, antisocial behaviour, fighting disorder, none of that. No member of the public has complained. No councillor has complained. They have absolutely nothing at all about this premises. And what I would say is that these are all allegations that my client is entitled to be innocent till proven guilty. And as I say, we believe that we've been operating without any causes of concern, and certainly I haven't been told any before today. And I've already asked PC Ryan, have they been to the premises on crime disorder? She says no, not that she can recall. And when I asked about why the police then visiting, they said they were asked by the licensing authority to do some visits. Now, I'm not suggesting that PC Ryan cannot visit, and she said, "Why we wouldn't ignore it, of course." But then you take it to the next step. We believe that we are providing food ancillary to alcohol. Coming back to good character, Mrs. Seskin has been running this premises for 6 years without any cause of concern. She felt harassed. She removed herself as the DPS because she felt she was being harassed, and thought that maybe by changing the DPS, the police or the licensing authority won't harass her long-term business. But they do continue to call and visit, and I have, as a solicitor, have offered the police to sit around the table and discuss the issues and try to improve on the working relationship. However, this application should be judged on its own merits. There's no primary evidence of crime disorder. Going forward, licensing objectives will be met. It's a small premises, no more than 40, all the things I've said earlier on. Does that answer your question, Councillor Smith?
Yeah, pretty much. Can I just bring back PC Ryan then, please?
Yes, thank you. I just want to answer some of those questions that Mr. Dadd has put there. In relation to the character of Ms. Seskin, police aren't disputing that she's not a lady of good character. However, we do feel that she's not a responsible operator for a licensed premises. And that has been proven here, and it's been proven in other of her premises where she's consistently breached the conditions. And that's where the cause for concern for police is. The records that the staff member felt harassed and couldn't give them to us were simply orders for the tables that we requested to prove that there had been orders taken for food. And the reason that he couldn't show us the orders were because there were none. And we visited on intelligence that was passed through to the council. The council did ask us to visit because they've been given intelligence, and it was passed through to police to visit.
Okay, come back, Councillor. Mr. Dadds.
Yeah, two very short points, Chair. Mrs. Seskin is already the licence holder there, and there's been no review. There's been no sitting down with her. There's no suggestion that she will not. Of the last 6 years, you've heard no issues arising, no drunkenness, no children, no issues at all. So the reality of it is that the visit about the documents, we do keep records, of course we do, and we've actually got the CCTV for the 25th. We've kept it. The officers already checked the temperature of the oven, which is always hot, gone round and spoken to the customers and seen what food was on the customer's table. The manager said you can go to any table, there's only tiny premises, and you can see the food, you can speak to the customers. The reality of it is that we've asked for the body cam footage to show that visit, and what we said to them, look, you can see in the premises. But as I say, it's all smoke and mirrors. Where is the primary evidence? Where is the crime disorder? Where's the witness statements? You haven't got any, sir.
Thank you for that, Mr. Dadds. I'm just like to bring in Councillor Ozen, if you've got any questions.
Councillor Smith, I haven't got anything to add.
Okay, thank you. I mean, I'm a little bit confused as well, I suppose, ultimately about this, because on the one hand, you know, the police are saying that, you know, Miss Hande Sezgin was recently the DPS at this premises, currently holds the premises license, but was replaced after police officers found breaches at the premises. And the breach, I think, it seems to be the major breach is selling alcohol without ancillary to food. And then the licensing team have gone round there. This venue was reviewed by Hackney Council licensing enforcement officers, resulting in Miss Hande Sezgin, the applicant, being banned from the premises when the premises license is in use in order to promote the licensing objectives.
Yeah,
So
Chair,
why-
sorry, that was relating to one of her other premises. My apologies. It's the way I've written it, not very clear there.
Oh, okay, so that's maybe why I'm getting a bit confused here.
Yes, I can. If I can just clarify, sir, there was a premises around the corner that's been subject to a bit of history. There's only one incident of crime disorder on the premises, but allegations of breach, which was subject to a review, subject to Mrs. Sezgin license being reviewed. But that's separate to this application. She's still a person of good character. This, the first point you raised about removal, no one removed her. The police didn't remove her. The licensing authority didn't remove. Mrs. Sezgin did an application to vary her license to put in effect her husband on as the DPS because she felt that she was being harassed by the officers and felt that she needed to step back a bit because of the level of harassment that she's been receiving. Now, you're not here to determine that. And I've tried to say to the police, look, let's have a meeting. Look, there are no fights. There's no crime. There's no disorder. The premises around the corner is the premises around the corner. This one has never had any matters arising at all. And the issue around food, we say food is provided. We have a food menu. However, we would like people to be able to come in and have smaller snacks or just come in to have a drink. It's such a tiny premises. It is within policy. She is a person, as you've heard from the police, of good character. She's not a criminal. It sounds like she is by the submissions it's been made, and she's never been prosecuted for a breach, never received a caution for a breach. So that's where we are. Not even received a fixed penalty notice for a breach. So what I'm saying is, let's get back to, you know, what is proportionate, reasonable. She's a hard-working woman with her husband. She's got the cafe by the bridge. She wants to allow customers to come in and have a drink with some smaller snacks. Why not? Doesn't cause a problem, and no neighbours have objected. So I know you've given me ample time, and I've amplified that. So, but thank you for allowing me to answer fully.
Thank you, Councillor Conway.
Just briefly, Mr. Dadds, I wondered if you could sort of respond to what the police said about this application essentially changing the license, you know, from one that was for restaurants to one that is for a bar, and that there are, you know, material differences between the two, and arguably this you know, Miss Sezgin doesn't have a track record in this premises for running a bar, but the track record that she does have is of running a restaurant, and that there's been a couple of warnings. I know that you say that nothing criminal has happened, but there's been a couple of warnings that we need to be mindful of. So, you know, how if we're going to extend that into a bar with a greater number of people, greater volume of drink, different atmosphere, where are those assurances for us that that's going to be managed effectively?
Yeah, thank you, Councillor Conway. Firstly, we made our application all those years ago and described to the police what we were doing, which is food led. And the police said, well, look, we don't have an objection as long as you take these conditions. And the conditions that we had, we got, and I don't believe we had a hearing and we got the license granted. So it wasn't imposed by us. That in fact, the wording, I think the conditions are ours. The premises actually are not going to change fundamentally because we are a cafe. We are predominantly cafe. We're not changing our business model, but we're allowing the odd customer to come in or a customer to come in. It's only a small establishment, as you may know, or you will understand. So we're not turning it into a vertical drinking establishment. We are predominantly food led, and I'm quite happy to have a condition that says the premises will be predominantly food led. There's no vertical drinking. You can only be served alcohol by serving at the table. And if we came along and just asked originally and just said, no, actually, we just want to be open like any premises to have food or drink and people are not tied, then the policy would allow it. I think we've been tied ourselves up years ago unnecessarily. This premises fundamentally will not change its operation. The odd occasion or in the week, some people may want smaller snacks or their friends may eat, one of them will not eat. So it allows to dealing with those types of customers. So I'm quite happy for a wording that says that premises will principally be food led, but I don't want a condition, we don't want a condition that everyone has to have food to have a drink. And in relation to running of the premises, round the corner, when she did run it, there were issues again about she agreed to the same condition regarding food. And Kerry Ryan, I think she can be candid, that she accepted in the end that condition was voluntarily agreed and actually it wasn't necessary in the end. And I think the police agreed to remove that condition so that even though there was a prosecution, not prosecution, but a review on breach because of that condition, a new license was granted to a family member where that condition no longer applies. So,
Right.
I mean, and that's my point, is actually, if a new applicant came along today, the police wouldn't insist on that condition. That is an historic condition that she agreed to voluntarily all those years ago, and she wants to amend it to give her some degree of flexibility. But principally, councillor, the business is not changing, and she has years of experience as a licensee. And you can see 6 years without any incident on that premises at all. Does that
Are you
answer
happy,
your
Councillor Conway, with that?
Yeah, although I did want some clarification from Amanda, if possible, about a condition, if there were to be a condition that said food led. I mean, is that enforceable? What does that mean? I mean, are you, you know, if you,
it can be enforced, because I've had it on other premises where it will be food led and food will be available, and that and you can say there should be no vertical drinking. So
no.
Yeah, so it's table service only, and it's got to be providing food, but you don't have to have food to have a drink, and that means it doesn't turn into a pub. But the hours that we saw, this could be that anyone could come along. These hours are not unreasonable hours, even if it was just a straightforward pub. Well, you wouldn't be restricting this. Look at the hours. But in any event,
what is the difference between that and a pub then? Why would you, if it's
because
if you introduce the food led condition when most pubs do sell food, what would be the distinction?
Yeah, the distinction is that we are food led, so that's predominantly that's our main core business. Secondly, it's table service only, and thirdly, that you so food led, table service only. I think that was did I say one other matter? I can't remember now. I've sort of forgotten that point. So it was food led.
Drinking, I think you said.
Oh yeah, no vertical drinking. Whereas you can go into a pub, just have a drink, stand up at the bar and order at the bar. So we're not seeking that at all. So there is a distinction. And remember, our capacity is tiny. Maximum, I think, is 40. Absolutely tiny.
So,
I think through the chair, I think the capacity has increased though, has it not?
Yeah, from I think 20 to 40. I think that was the.
so am I right, Mr. Dadds? That
There are conditions, as which Mr. Dadds has described, that we have had conditions like that in the past. So I can say that is correct. So I won't dispute that.
So, Mr. Dadds, am I right in saying that you wouldn't be up for drinks being served with a table meal, for example, only served with the table meal? So that
No.
you're not for that. You wouldn't
No,
accept the
because
condition on that basis.
because we've already got that in effect. Well, we've got a condition less than that, but no, we're not. We want to be able to. If you come in, Councillor Smith, with Councillor Conway, and you have food, and Councillor Conway just wants to have a drink, we should be able to serve you at your table a drink. Or if Councillor Conway only wants to have a small tapas, not a substantial meal, then we can do that too. And and so that's we're moving to no more than 40 seated patrons at any one time, and you've got to have table service.
So what kind of an establishment would you describe this as?
I would describe it as a cafe food-led premises, but you can buy you can go in if you want and have a drink and have a sandwich or have a tapas or sit with a friend and have a drink while they have something to eat, or you could just go in. It's a small, very boutique cafe where you can have a drink if you want to, a coffee, food. It is, without a shadow of a doubt, food-led. No one can dispute that.
Yeah, I mean, the police say on their the stuff they've written about this application describes itself as a licensed restaurant.
Well, I think actually, let me just see what can I just because it is at the moment a licensed restaurant. Yeah, it is in effect food led, but there are many restaurants that don't have a condition that says alcohol should be ancillary to food. Many of them, you can go in and just have a drink. You can go to the bar and have a drink, or you can have a drink beforehand, eat your meal, stay after and have a drink afterwards. So this is, as I say, I think we're getting ourselves, I don't want to be disrespectful. I mean, if this was just a straightforward application for a new license without any history at all, this would fit within policy. The person's of good character, company has no issues arising about it. The no residents object, no councillors. I mean, the conditions we're putting on it are restrictive. Look at those conditions, councillor. It's at what page is it? I think.
Yeah, no, I've been looking through them.
Yeah, they're quite. Do you know what I'll be quite candid. They are quite robust. 8 through to 26 is what we've offered, and then 27 to 32 is what the officer wanted for the environmental health. You know, This premises has been operating for 6 years. I know I've said it multiple times. I'm repeating myself, but you will not find one issue arising in the way we've operated in the past.
Yep. Thank you for that.
Thank you.
I mean, the condition that we're referring to is 19, really, ultimately, in regards to the food-led thing. So 19 would need to be updated, Amanda, because it currently states that the sale of alcohol shall only be by waiter service to seated customers, and there shall be no direct sales of alcohol to customers standing at the bar. And
yeah, that's all right. That's acceptable.
So how can we fit in like a kind of food-led type wording in there?
Obviously, Amanda North is here, but I would just say that the premises should be food-led, and there should be no vertical drinking. That's it. Because that means you have to provide a kitchen, a chef, ensuring that food is available at all times. So you could say food is available at all times. Sorry, Amanda.
Yeah, sorry. Chair, I think what you need to get to the bottom of is, if you wish to raise that line of questioning, is whether or not the police, from what they've heard from the applicant's representation, makes any difference to their view and their objection to the application. Because you know, I think ultimately, you know, they know whether or not, or you know, they can clarify whether or not there are any issues that still need to be sorted. Because if things were as straightforward as Mr. Dadds is saying, then I'm sure they could have agreed something by
Well,
now.
no, it's not as simple as that, Amanda, because there is a difference between us, because that the police, that we say that there's been some harassment, and there's no primary evidence here. The reality of it is the police will confirm they've not. I've said it multiple times. There's no primary evidence of crime disorder, and it's forward-looking. So the police would have to. The burden, I think, is on them here, not us, to show that with these conditions, the licensing objectives will be undermined. The burden, I'm right, Amanda, isn't it? The burden's on them to demonstrate to the councillors that the licensing objectives will be undermined. And I haven't heard anything.
There is that, but there's also a duty for your client to demonstrate that they will responsibly operate the premises and that the licensing objectives will not be undermined.
Yeah, and we can say that we've operated 6 years.
Yeah.
We've had no cautions, no prosecutions, no reviews, no fights, no disorder, nothing from Environment Health, nothing from residents, nothing from councillors. We've had a number of allegations this year which we dispute and say that we will challenge should the police produce their evidence to the contrary. We are a person of good character, and our character is being attacked here, where's the evidence for that? And if the police genuinely believe that there was a undermining, or that the Section 136 of the Licensing Act was being breached, then they could prosecute.
Okay, but Chair, also the licensing authority still are objecting, although they're not present here tonight. Their representation still stands. So, I don't know if Mr. Dadds has been able to overcome those concerns.
Yeah, Mr. Dadds, can I just chip in here just about the planning for the terrace, really? Because in the licensing page number 84, which is the licensing representation, they talk about, planning records also show that the roof terrace has permission after being allowed by the planning inspector. This enabled the continuous use of the existing seating area on the terrace floor, including the metal balustrade, for safety reasons. And it's noted that the following condition was attached. The roof terrace hereby permitted shall not be used outside the hours of 0800 to 2200, Sunday to Wednesday, and 0800 to 2300, Thursday to Saturday.
Yeah, that's our intention. And if it is open any longer, that we'll make an application.
Okay, so is that in the conditions? Is it? This one's actually in there, is it?
No, it doesn't have to be in there as a condition, but we're quite, because otherwise we would need to have to come back and vary the license. The planning and licensing are separate.
Okay, I got
but
you.
Obviously the planning authority have not raised an objection, nor has the noise pollution team regarding that. And what I would say about the could I just comment briefly on what Amanda asked you about the licensing authorities?
Yep.
Just very briefly, look, they have never issued us any cautions, any sit-down meetings, any formal action. They raise a number of issues regarding planning, which is separate regime, and they raise the premises regarding around the corner, which is not this premises. But what they don't put in here is that Mrs. Seskin has had this premises. They don't say at all here that the licensing authority have had any issues with this premises, which she has held the license for 6 years. Not one.
Yeah. I'm going to ask you a straight question now about the terrace. I mean, would you consider having a condition like that in there?
Yes, absolutely. If it was the difference between us getting the license, not, of course, sir.
Okay, well, that's good to know. Thank you for that. Okay, look, I think, Councillor Osen, you've been very quiet. I just want to give you an opportunity during the discussion just to come in if you want.
Actually, I've been listening, and it's very interesting discussions going up there. And then I was going to ask you one other thing. Is there any outside? Do they have any tables outside?
Yeah, we have a tables license, pavement license.
Yeah, how many of them?
I think we have 2 tables. Do we? How many tables, please? 3 tables, but that's licensed by the council.
Yeah. Okay, was that it, Councillor Osen?
Yep.
Brilliant. Okay, well, I mean, I think we've kind of we've had the discussion phase. Just nod if you're happy with that, just to make sure, because we can kind of move on, I think, a little bit now to closing remarks. So if I could just ask PC Ryan just to come back with some closing remarks, please. That would be very useful. And then obviously the applicant can come back and etc. And Suba, if you need to say anything, or Amanda. Yeah, so PC Ryan, please.
Thank you, Chair. Yeah, I'll just go over the quick changes that we see from this license, the existing license to this one. And that would be that it would be changing from a restaurant to a bar, that the capacity would be almost 3 times what it is now. It's 15 on the current license and 40 on this one, which is rather a large jump. If this was a new premises license with somebody completely different, we would still request that there be an ancillary to food condition. This is not just because of the current operators. Our concern is with the suitability of Ms. Seskin as an operator. The reason we haven't done anything else with the other license at the moment is because it becomes very difficult to deal with licenses when there are several applications going on at the same time. It can become confusing. So our aim is to deal with this license in the first instance, and then we will move on to discussions about the existing license. Yes, the license does fit within the policy. But as I said, our main concerns are around the operation and whether we think that the operator is responsible enough to uphold the licensing objectives and to keep the conditions that would be on this license. Thank you.
Thank you for that, PC Ryan. I'd just like to refer to one little passage in your representation where it says this area has attracted complaints from residents. Could you just talk to that a little bit, please, just for a couple of minutes? PC Ryan, thank you.
Sorry, let me just find it.
Page 81. It's 1, 2, 3 in the 4th paragraph.
Right, this area, yeah. So the small block that this premises is on, it goes back out onto the canal, as does one of their other venues. So I mean, as does other venues too. There's been complaints about these venues from residents in relation to noise, and I think sometimes sometimes they've been named in the complaints from the council, and sometimes they've just been in the general area. So I haven't been able to be specific.
Yeah. Okay. Brilliant. Thank you. Okay, Mr. Dadds.
Yes. Thank you, Chair. Well, I'll do it in the reverse. Firstly, the noise team don't raise any objection on noise complaints. I've not been provided by the police any evidence of any noise complaints where we're mentioned. No councillor, no residents object to this licence, not one. The business is not changing from a restaurant to a bar. This is a restaurant with a bar, and it's going to be predominantly food-led, table service only, no vertical drinking. Mrs. Seskin is a fit and proper person. That test went years ago, but in any event, she holds a personal license. She's transferable. She's not got any cautions, any convictions. She is a woman of good character, and that is a matter of law and fact. I mean, it's a golden thread in our country that you are innocent till proven guilty. If the police have a complaint about a number of visits, which she has disputed, and I've spoken to the police about that, we have the evidence, they are incorrect, they are wrong. They've taken no further steps about that, but to muddy the water here today, and that's not the right place. The right place would be either to deal with it informally or through the magistrates' court. But what the police don't say, which speaks volumes, and that's the Daniel Thwaite principle, is that look at the primary evidence. She has been a woman running these premises for over 8 years. 6 years of those is with a premises license. Never been reviewed, never received any cautions or any enforcement action other than the recent warning letter, which she disputes. Not had any other matters, material matters arising, no fights, no disorder, no evidence from the police at all. No, not even any specific evidence of mentioning of complaints from members of the public. She has run this cafe restaurant for years impeccably. If every premises in the borough run it where there's no drunkenness, disorder, fights, anything like that, as she's got here, you would be saying we've got a great borough. Yes, this is a type of premises that needs to be supported, and not these objections. Now, the police said in the closing that this application is within policy, and it is. And within policy, it does not ask that there should be an ancillary to food condition. It's within policy, and it can be granted because it's within policy. As I, for all the reasons I've set out already, we will sort out this issue about food ancillary falls away if this license is granted anyway. And then there's nothing else to complain about because there is no crime, no disorder, no noise, no public safety. So, and we will obviously sort out the planning in relation to upstairs if we want to go later, Chair, separately. So, you know, what they're complaining of, allegedly, would fall away because the license be granted. And it is the right way to come along and say, look, I would like to be able to, if someone's eating, for someone else to be able to have a drink with them if they want to be. If someone wants a snack, not a substantial meal, they should be able to. This is a food-led premises, and I ask that the license be granted on its merits with the track record history of 6 years, and with no information, primary witness statements, signed witness statements from the police to the contrary. And I ask that the application be granted, Chair, Councillor Conway, Councillor Osden.
Yeah, thank you, Mr. Dowds. Just 1 second, Amanda, before you come in. I just want to clarify one final point about, because the application's been submitted by HS Hackney Limited. I'm assuming that that Miss Hande Sezgin will be the DPS, right?
No, no. I think we have it as the existing. Let me just have a quick look. Sorry, I apologise. I need to be reminded.
It's somebody new with the surname of Poco.
Yes, I think that is the manager. Yeah, that's right.
It's
So
Mark Andrews Poco.
Yes, I believe that's right. But the current, so that you know, the current license is in Hande Sezgin's personal name, as I believe, and then this is obviously a company that she set up, which she's the sole director. So,
Okay.
So there's no hiding the facts; it's all there, and she holds the license. If this license is granted with no, and we're satisfied with it, then we'll be surrendering the old license.
Okay, and just Mr. Ismail Tezgel, he's the current DPS for the current license.
Yes, that's her husband. Yes.
Right. Okay. Great.
Thank you.
Okay. So, thank you very much, Amanda.
Chair, I just wanted to ask if we could, if you wanted to ask Mr. Dadds why Mrs. Hande Sezgin is not present here today to make any representations.
Oh, sorry, she is next to me virtually on the computer. I'm in Cambridge. She's in London. She's been listening to all of this, and that's when I looked to get the instructions.
Many members would like to ask Mrs. Sezgin any questions. Chair, I don't know whether you were aware of that, and therefore, do you have any questions for her?
I'm her representative. I've answered all the questions with her with my instructions, and she's next to me. So, I mean, I've done all that. If you do want to ask a question, you can.
It's always good to hear from the actual license holder themselves.
Well, that's fine. She's here. If you want to ask a question, Chair, she's here. But I'm obviously the advocate instructed to speak on her behalf, and that is not unusual. Especially when it's virtual. If we weren't in a virtual meeting, she would be sitting next to me in the town hall. Yeah.
I mean, how do members feel about this? Would you like to, 2 minutes from from Miss Hende?
Also had an operation.
Councillor Conway, how do you feel about that?
Well, I think actually we've come to the conclusion. I've done the summary, but if there's any questions, she'll answer any you have, or I could ask her just to. Hyundai, can you just confirm everything I've said you agree with and you're happy with my submissions? Anything further you want to add?
Yes, I do.
You're happy with that, thank you. So those have been her submissions. She's adopted those on her behalf.
Okay, well, that's fair enough, unless other members have a
Thank you.
problem with that.
There is no problem. Just
Okay, great.
Thank you.
Well, thank you very much. So this is an opportunity now, step 8, just for final clarifications, which I think we've kind of done, unless members have any further points of clarification. Councillor Conway or Councillor Ozen, any further points of clarification you need?
not from my point.
Okay, fantastic. Well, thank you very much, everyone, for coming to this meeting. There being no further business for consideration here in regards to this particular item, all participants involved just to be advised to log out of the meeting promptly. And thank you very much for coming along today.
Thank you, councillors. Good night. Bye.
Good night. Thank you.
Thank you, officers.
Thank you. Bye.
Thank you. Thank you.
Chair, if I can just ask if we could, if the members could retire with me just for 5 minutes before Councillor Ozen has to leave.
Yeah, I'm
I
just
think
wondering how we
if you
do
could
that.
return to the meeting room that we were in before this meeting, if you
Yeah.
could return to that meeting room, that
Yeah.
would be best.
Okay, Craig, Hi.
Sweet. Yeah,
Yeah.
now I'm here.
Big apologies about that, Craig. Sorry,
Oh,
really
yeah.
sorry for keeping you holding on.
That's all right.
The other one just took a bit long.
Mhm.
Right. Okay. So let's continue with this one. So thank you for being patient, Craig. I know it's frustrating. You probably have something to do this evening. Okay. So if the licensing officer could please outline the report for this one, please. Thank you.
Thank you, Chair. Licensing Service received an application for the variation of premises license under Section 34 of the Licensing Act 2003 for 47 Broadway Market to remove off sales and to authorize the supply of alcohol for consumption on the premises, as stated within the report. Representations to remain from one other person. The applicant has submitted additional information which has been circulated. I'll have nothing else to add. Thank you, Chair.
That's great. Thank you very much for that, Suba. And so, Craig, I presume you're representing yourself, yeah?
Yes, I am.
Fantastic. Okay, so I'll put you on the clock. You got 5 minutes, just to present your case. Thank you.
Okay. Yeah. So basically, we've run a restaurant on 49 Broadway Market for 7 years, and we're looking to expand by taking the lease next door. This lease was originally 47 and 49 were originally one unit, and in the future, like, we're going to look at joining the two places, but originally there'll be two separate premises, licenses, and run separately. We had some temporary events from January to April of this year, just to test out the venue and see what it's like, and give the locals the opportunity to discuss us moving next door. We had 2 complaints from the flat above, I believe, during that time, and that subsequently made a representation for us not to change the premises license. But overall, we've had a pretty good history in terms of upholding the licensing objectives. And from that incident, we did identify, like, the incidence of the noise issue. We identified just basically music-led events and DJs being the main problem to that. And originally, we did plan to have those DJs kept at a background noise, but it just didn't seem to be. We weren't able to manage that, so we've just removed them from any future purposes. And then the next thing we actually did do was just to rent it out in the meantime for a promotional service. So we actually have stopped using DJs. We have, like, a good record promoting the licensing objectives. Our landlord is quoted to say that, like, one of the reasons that he gave us the lease we purchased the lease for 47, but one of the reasons he did choose us is that we did have a good track record, and I think his exact words. Also have to be mindful of the flats above and not let a new tenant cause them any disturbance, which favours you being OCO and your past record of OCO. So although that we've had those 2 incidents recently over the 6-year period, we've had a good record. We also have really early closing times, so we're not a late night license. We're not asking for late night refreshments, which is the main reason that we want staff to get home early. And we do have reasonable closing times as advertised on our website, although I think the Sunday now is till 9:30 at night, where Monday to Thursday, our, like, closing times actually around 10 o'clock. And from February to March, 50% of our last orders were actually before 9 p.m., which is a little bit winter orientated. We've also removed the off-license part of the premises because we know that was causing a problem in the recent COVID periods. And we had a complaint that we were changing the classification of the premises from a grocer to a restaurant, but these are all E1 classified, and previously that both 47 and 49 had been classified as a restaurant, and A3 I think it is under the old system. And all this information is available from the planning documentations on the planning portal. So there was records of that, of the 2 sites being joined, both of them registered as a restaurant. We've discussed the use of next door as a restaurant and with an acoustic specialist, and they say that although that you do need something, that it's not like a major consideration as long as it's not a noise-backed entertainment, and that's where we had the problem in terms of noise and nuisance noise. And we did have a mention of the outside seats, which was actually the street market trading seats that are actually technically run by 49 and they're in front of 47, but we haven't had any complaints about the seats. And they are like from 49 and they're actually very close to 47 already. So over the 7 years there, we haven't had any complaints for the outside seats making noise, which we did reference would be somewhat to do with the awnings and the bamboos and the wooden box on top actually holding in some of the noise. And that, to be honest, is like the main considerations. I think that we've been running a successful business that has applied the licensing objectives for the last 7 years, and we believe that like the place next door actually has been a restaurant before, and we want it to be a restaurant for the future. We will in the future be looking at varying the premises as we grow, but for the initial premises license, we've given the basic layout of what it currently is and what we can do without any planning permission and with a limited amount of people. So that's basically what we're looking at. I know that there's been two layouts that have probably been circulated, and the reason that we circulated the second layout was we just wanted the flat above us to understand that we will actually be changing the premises license variation layout in the future, and we just didn't want to like blindside them to that fact because we had mentioned it to the other authorities, being the police and environmental control.
Okay, brilliant. That's it. 5 minutes and 30 seconds. Perfect.
Thank you.
Great, Craig. Thanks very much for that. Okay, so we have other persons, and obviously they're not here, but we are going to note Appendix B in the report as to what they have been talking about. I think we can kind of move into the discussion phase, Councillor Conway, if that's okay. I think, we'll just move straight there. Do you have any questions that you'd like to raise at this point at all? Councillor Conway.
Yeah, I suppose I'm just a bit curious about, the resident from Derricote Street, the complaint.
Yeah.
I know the area well, and I'm just trying to figure out how
Sorry.
somebody who lived arguably quite not that close to.
No. They're actually the flat above. So it's strange. It's addressed. The postcode is Derricote Street, but they are literally the flat
Right.
above us, I believe.
see.
So
I see.
yeah,
Okay.
that's
Okay.
the occasion there.
Okay. Thank you.
So Craig, just sorry, Councillor Conway, you might want to continue. Sorry for
No, that's
interrupting.
okay. You go.
Yeah, Craig. So the other person has just mentioned that they obviously concerned about noise, coming up from there up into their flat. They've also mentioned that they're concerned about outdoor seating. They've noise levels from customers eating directly under my living room window. Especially as we begin to see kind of the warmer nights coming, and things and stuff like that. And I know that you had a lovely picture of an awning from Australia, which kind of overlooks the seating area. Am I right in understanding that you were not considering doing that because of planning?
I don't think that. Yeah. So just trying to find the photo. What I was saying is actually at the current situation, there is no awning out there, or there's no protection. And what we're saying is, well, we will be putting an awning there, and when we do put that awning, we won't be using the awning from Australia, but at a certain level, if you make that awning, for instance, if we use a wood awning as opposed to a canvas awning, it actually is better at absorbing the sound of going to the flats upstairs, even the positioning of like bamboos on the side of the street. Now it's not part of technically the premises license, it's shopfront trading, and it's actually currently run from 49 Broadway Market, not 47 in a sense. So what we're saying is that even though that's the case, is that we've got like 6, we've been limited the use of it to so that there's currently just 6 tables which we'd want to move. But in summertime, that is a noisier street, and I know that it's like outside her living room. Her living room is directly on that street, so we've been operating outside seating within the same, basically like a meter from the living room for like 7 years, and we haven't had any complaints. And I know that, like, obviously putting the seat there now is more of a complaint, but it is a market street, and we are willing to put an awning out there and take that into consideration. But I don't see like that as a consideration for anyone else that has done like the seating on the market
Yeah.
street.
No,
So
the only reason why I referred to it is because you sort of mentioned it in your pack.
yeah.
And I was sort of intrigued by the type of awning you were kind of suggesting. But yeah,
Yeah. So that what we've suggested with that is basically the acoustics person suggested, well, it's the mass of the awning that you put in. So
yeah,
if you can make the awning with more mass,
yeah,
it'll be a better effective
yeah,
at blocking the noise, which is kind of what they've done. What they've done in that Australian version, they've got a normal awning and they've run a like another
yeah,
sheet, quite a heavy sheet underneath it, and the curvature of
yeah,
the things
yeah,
does help. And so at least for the flat above us, I think that we could actually do something that has a real effect on lowering
yeah,
the noise there, but
yeah,
we can't do it until
yeah.
further
Okay.
down the track.
Councillor Conway, I've got a few more questions. I mean, I can carry on, but if you want to come in, please.
No, you go ahead.
Yeah. So just on the conditions, condition number 5 that you provided in the ancillary document, no music or amplified sound shall be generated within the premises so as to give rise to a nuisance within the neighbouring dwellings. I presume you're happy with that, yeah? You're happy with that?
That is actually from the environmental control people put that in
Okay.
for us.
Would you be happy to have a condition where that was in your
I
license?
am unsure as to what that condition means, because I found that I asked the environmental control to come back to us on that, and like verbally I've agreed with it, but I asked them to come back. There's no music or amplified sound to be generated within
So
the
as to give
premise.
rise.
And so is it the music and amplified sound that's not allowed here, or is it the nuisance to neighbouring dwellings? That's
It's basically the nuisance from amplified sound and music giving rise to nuisance, essentially.
Yeah, so I'm like just confused as whether we're allowed to play music there or not, or is this the case we're allowed to play
No,
music?
you would be allowed to play music, but as long as the person upstairs didn't hear it, really.
Yeah, I mean, so like I'm obviously happy with any for it to go through, but
I think there's probably a difference between hearing it and a nuisance. You know, if it becomes a nuisance, then it's a problem. You know, that's the issue. Which would lead me onto the next point I was about to make was, you know, as you're about to, when you come to sort of knocking these two buildings together, or that floor or whatever, you know, when you're doing some works. So question 1, is there any treatment to the current ceiling in the other place, 49?
Yeah.
You know, and how's that working with the upstairs people? And then obviously 47, I would suggest that whilst you're doing the work, maybe consider doing something up there, you know, on the ceiling.
Yeah, so we're
Does that make sense?
Yeah, in I think so. If I can answer, maybe we'll see. I think in 49 that we haven't any complaints. We've specifically asked the person, and they've said that no, any noise hasn't bothered them. As to whether they hear noise or not, I'm not too sure. The layout is
hold on, Craig, 1 second. I mean, they in their representation, they do make.
No, sorry, I meant 49. In 49.
Oh, 49. Okay.
Yeah. In 49,
yeah. Sorry.
did it. And then in terms of, I think that I've mentioned in what we're looking at doing is putting in a layer of insulation, particularly when you're knocking through, because there will be, assuming if you're joining the two places, there will be extra noise. Putting a layer of insulation on there, and then covering that in a wood. So we are looking at insulating it, particularly if we knock through, because that will increase more noise. As to what that is specifically, I don't know, but a layer is it's either kind of a rock wall thing or it's a plastic covering that goes over. So we'll do it.
I mean, you can get a special acoustic foam that you can use as well. You know,
I agree.
In a void space like that.
So that's the other thing is, well, what we've currently got now is the 47 ceiling is actually the previous tenants just stripped all the lighting out of there. So you've actually got holes in the ceiling. So we will look at most likely replacing the whiteboard, so the ceiling plasterboard. And then when we're doing that, is you can actually look to see the quality of the insulation within the cavities. But what we're probably looking at is then once you put the plasterboard, you're putting an extra layer of insulation on there. then
Yeah.
rather than a drop ceiling, which isolates the ceiling from the floor kind of thing,
Yeah.
it's actually just a layer of insulation, and then we're actually kind of covering that with wood. We're also looking at like putting in things that absorb sound, so it's plants and soft materials such as cushions that help absorb sounds. Where I'm a little bit worried about is if we put this no music or amplified sound should be generated within the premises so that as to give rise to a nuisance within the neighboring dwellings. I'm worried if that is actually a legal requirement and we're in breach of that, that's a criminal act that would be in breach of in creating. I'm just worried at how that is judged.
Amanda, could
from
you
the-
clarify that point?
Right, sorry. Yeah, sorry. It's the condition number again. What was?
The condition
Number 5 and the additional documents.
Okay.
Can you see that in
Yeah,
orange?
just bear with me.
You can read it there on the screen, can you?
Yeah. I can't quite see it on the screen. That's the thing. Could you just
Alright.
read it to me again, please?
Yeah, it just says no music or amplified sound shall be generated within the premises so as to give rise to nuisance within neighbouring dwellings.
Yes, that sounds to me like a standard condition.
Yeah, so if they were in breach of that condition, what Craig's asking, is that a criminal offence?
Yes, because under the if there was a noise abatement notice issued, then yes, they would prosecute for failure to comply with the noise abatement notice. So what they would do is, if there were any breaches, they'll probably build a case which could be prosecuted under the Environmental Protection Act 1990. So
I'm like,
but it would obviously depend on the local residents, you know, making a case that you had breached that condition, you know, because they'd experienced noise nuisance late at night.
Yeah, I suppose, Craig, what we're trying to get at here is we want to avoid that neighbour upstairs basically sort of, you know, being hassled really, and for you to be hassled by them. If your restaurant's going to cause them problems, they'll always be down. It'll just be unnecessary strife for both parties. So we're just trying to make sure that we can alleviate any of that stuff before it happens.
Yeah, I mean, look, I'd say I'm happy to put that in. I'm just worried about the actual how it will play out kind of thing in terms, because it does.
Amanda, sorry, 1 second. Amanda, is there any way we could reword that to make it slightly less tight, if that makes sense? In other words,
is that condition though issued by the Environmental Protection Team?
I believe so. I mean,
yeah, if it is, then I couldn't amend it. We would have to ask them to change it, or
okay,
we'd have to ask them to comment on it. I couldn't make the amendment, only because Suba, I know you want to speak, but basically we have to be careful that we can't infringe something that they would expect to be there in there as a standard. Suba.
I think sorry, Sue, 1 second. I think what Craig's worried about is basically if he plays any music at all in there, that the person upstairs is going to complain and then he'll be up for a criminal conviction. Whereas I'm thinking, well, if it's background music in a restaurant,
but it's talking about amplified music, isn't it though?
Yeah, it doesn't mention anything about background music. It does say amplified music, but to be honest, any kind of music is pretty much like a radio is amplified.
Yeah, exactly.
I can have a beeper like on the calling thing, and that's what I'm saying.
All we could do is ask the Environmental Protection Team. Unfortunately, they're not here, but ask them to whether
Councillor
or not.
Conway, do you want to come in on this point? You might have some ideas.
I was just thinking that I think the point, Craig, for you to focus on is the nuisance point as opposed to anything else. So it's not about whether you're playing music or not. It's about whether you're causing a nuisance, which arguably, I think it would be reasonable for us to have that expectation of any person seeking a license in Hackney. It almost feels a little bit unreasonable for us to not be able to say don't cause a noise nuisance to people who live above the premises. Do you know what I mean? So I think that would be the focus. I think maybe where there could be some clarity, Amanda.
Maybe the hours on which this happens, like after 10 o'clock or something. I don't know.
Well, that's an idea.
It is, but Amanda, I was going to say, I mean, how is nuisance determined, though? So would it be?
It's got to be measured by the Environmental protection
So
team.
environmental health. So that's the thing. They are able to determine what is a nuisance. And even if this
Mm.
wasn't included, if
Yeah.
you caused a noise nuisance, environmental services would be, you know, around
would-
anyway. So
yeah.
to me, I don't think that this is a
We can ask them
problematic.
to consider
Yeah.
it, but I mean, it's really unfortunate we can't, members can't amend it
No.
because
Yeah.
it's from
I think
environmental.
Suba wants to come in. Suba,
Yes,
one
yeah.
second, Craig. Suba.
Sorry, Chair. I just want to confirm. See, the environmental protection team has spoken with the applicant, and he has agreed to this condition. If you look within the report, it's just based on that. Environmental protection has withdrawn their objections. So
Mm.
if the applicant was not sure of it, then he should have told environmental protection, so we could have invited them for the hearing for the further clarification.
Yeah,
Yeah.
Craig, you can come back on that one.
Yeah, I did actually email them and I asked for some clarification on that, but I just didn't get back. Once again, like I'm actually happy to put it in. I was just worried about how someone like what we actually mean for a nuisance, and then
Yeah.
how would it be? Because it is, you know, it is actually a criminal charge to break any of those rules.
Yeah,
I just wanted to
I
that-
think,
that's been
Craig, though,
clarified.
if you you've discussed the idea of looking at some soundproofing for the ceiling. Now, if you do that well, and it is possible, I am a bit of an acoustic specialist. If you use the proper stuff, I mean, well, you know, I've worked in sound for like 25 years, Councillor Conway. You know, if you use the appropriate stuff, you can definitely alleviate some of the problems, right? And so that in that way, you would be able to play some music or whatever, record it, amplified, without it being a nuisance to the person upstairs. In my opinion. And if you're going to be doing the works anyway, you may as well. That would be my advice.
Yeah, no, I agree, and I'm happy for it to be on there.
And measure it and speak to it, and maybe speak to the residents as well, and you know, and see if you're able to speak to them to find out how things sound for them.
Yeah.
Yeah.
And then, Councillor Conway, can I just finish off?
Sure.
Yeah. So you talked about the timings that you sort of finish in the winter and things. Because at the moment, the hours that you're applying for, there's a sort of difference between the closing time and the sort of the end of the license period, if that makes sense. So I'm just wondering if we could maybe get those
time.
Just get those sorted out a bit, you know, because at the moment the hours are what you see here
are the same,
and the closing times are the same as the hours on there.
They need to be 30 minutes less.
So I don't know if you want to close half an hour later or half an hour earlier, if that makes sense.
I would like, because it's mine. I actually did ask this for a little bit of clarity here. So it's my understanding that I wouldn't want to like lessen our supply of from the standard. Like I wouldn't want to lessen our supply of alcohol from 12 to 11 o'clock on the basis. So I'd prefer to extend the operating hours.
The
that at
hours,
least gives us.
If you extend those by half an hour,
to give us the leeway, because as I say, like our actual operating hours are different, and I think this is the case for a lot of places. The actual hours you could put into the supply of alcohol.
Okay, so that's what I'm trying to work out. Are these the hours that you want? Because if they're over the hours that you want, then maybe you should go for less. If that makes
that's what I'm getting at. I don't want to like put us in a situation where we're actually asking for less straight away, in a sense, in the case of, because it gives us less opportunity. Like it gives, like, there's more chance of making a mistake if I'm reducing the hours, and I don't see that the hours are actually.
These hours are fine by us. I'm just asking you what you think.
Oh yeah, no, I mean, I suspect that possibly, given that thing, that actually, so from what I've read, is the opening hours should be actually half an hour after the
that would lead me on to the question about you mentioned about staff leaving and be able to catch not the last train or the last bus or whatever. So, and obviously
Sarah, I think you need to clarify that it's in accordance with our policy. It has to be a drinking up time of 30 minutes before closing. So all the hours on the Monday to Sunday need to be reduced by the 30 minutes so that it corresponds, so that you do close on at that time.
Or encrypt.
Or the opposite way, or he closes half an hour later than these hours.
Well, I don't know if that would then make it beyond core hours, would it?
No, it wouldn't.
No. Okay.
So is that what you want to do then? Close later, yeah?
I would put in close later on the sheet rather than because I know. Yes.
Okay, so Subi,
Subi,
do you want to come in?
Sorry, Chair. I thought the applicant has already discussed with the police and they have agreed condition 19, where
19.
the premises, condition 19, where the premises will close 30 minutes after the alcohol timing. So I assume the hours, alcohol terminal hours should have been 20 to 30. So
Okay, so that needs to be amended then, doesn't
condition
it?
number 19, please.
Yeah.
I thought that's what has been agreed with the police.
Okay, well that's great to hear, but that needs to be amended on here, doesn't it?
Yeah. So
Mhm.
so the applicant needs to be aware that what has been agreed with the police. Please, can you refer to the condition 19, Chair?
Yeah. So I think you have agreed that already, Craig, by the sounds of it.
Yeah. I mean, I know that there's the terminal hour, or whatever it is. It's a half an hour. So
Yeah.
it
Thank
should
you
be
for that
different.
clarification, Suba. Councillor Conway, do you want to ask any other questions?
No, I don't have any other.
Okay, well, maybe we could just sum up then. Closing remarks. Craig, if you want to make any closing remarks, I think we've heard pretty much everything.
Yeah, I think that the previous things that I've said are pretty good. That's where like a long-established business, and we're going into a site that has been built for a restaurant.
I mean, it
for a
sounds to
period of
me like the
time.
person upstairs is just worried about the sound traveling up there. That's what they're worried about, and if we can mitigate against that, then everybody's happy.
I agree.
So that's it. Well, thank you very much. That was it. So I think there's no further business to consider here, Craig. So thank you very much for your time, and sorry to hold you up. It was a long hold up. I really apologize about that. Sometimes it happens, but thank you very much for attending, and we'll go away now and deliberate, and you'll hear in 5 days, or you can phone them up tomorrow.
Okay. Thanks a lot, guys, and I will
Okay.
be going. Thank you. Bye.
Thanks very much. Cheers.
You too. Thanks.
Thank you.